The Supreme Court of the United States of America, the interpreters of the law. And from the founding of the country, the Supreme Court would maintain the framers' original intent behind the First Amendment.
On every question of construction, carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifested in the debates, and instead of trying what meaning may be squeezed out of the text or invented against it, conform to the probable one in which it was passed. Thomas Jefferson to Justice William Johnson, 1823.
The first and fundamental rule in the interpretation of all documents is to construe them according to the sense and the terms and the intentions of the parties. Joseph Story, Supreme Court Justice, 1833.
But with the coming of the 20th century, a revolution occurred. It wasn't a violent revolution, or even a very obvious one. It happened in the quiet chambers of the United States Supreme Court, and it was led by 5 judges. In 1943, an anti-Catholic activist sympathetic with the Ku Klux Klan filed a lawsuit against the state of New Jersey for paying the transportation costs of busing children to Catholic schools. His name was Arch Everson. In Everson versus Board of Education, 1947, the Supreme Court used the opportunity to do something it had never done in the history of First Amendment jurisprudence.
The Supreme Court reached the conclusion that the First Amendment's non-establishment clause did apply against state and local governments for the first time.
Everson is such a landmark case for 2 reasons. One, for the first time, it clearly incorporated the Establishment Clause so that it applies to the states fully as much as it applies to the national government. And secondly, the language of Everson is near absolute in terms of church-state separation.
Neither a state nor the federal government can pass laws which aid one religion, aid all religions, or prefer one religion over another. In the words of Jefferson, the clause against establishment of religion by law was intended to erect a wall of separation between church and state. That wall must be kept high and impregnable. We could not approve the slightest breach. Justice Hugo Black, Everson versus Board of Education.
Now, a couple things are worth noting. Here, the court adopts the words of Jefferson. Jefferson, of course, is an important figure in our history, but he was not directly involved in the framing of the First Amendment. Not only that, of course, the Supreme Court is drawing on this Danbury Baptist letter, a letter that was written a decade or more after the First Amendment was crafted. Now, the court not only elevates Jefferson, but really makes his metaphor sort of the central organizing theme of its analysis, really establishing the wall of separation metaphor as a rule of constitutional dimensions, replacing in many respects the actual text of the First Amendment.
It was indeed a revolution, and the Supreme Court later admitted it.
The revolution initiated by the adoption of the 14th Amendment involved the imposition of new and far-reaching constitutional restraints on the states, reversing the historic position that the foundations of those liberties rested largely in state law. Justice William O. Douglas, Walls versus Tax Commission, 1970.
But there was yet another twist in the courtroom drama of Everson. Even though the majority affirmed Jefferson's wall against the states, the final decision claimed that the state of New Jersey had not, in fact, violated that separation.
The language was extravagant, to say the least. That almost this total separation between church and state with this impermeable high wall between the two. Well, then what did they do? They turned around and said, oh, by the way, it's okay if New Jersey reimburses the Catholic parents for sending their kids to a Catholic school. Well, at that point, what's going on?
There were certainly many Catholics who sought a victory because this would allow the continued transportation of children to their schools and the reimbursement of those costs. But there were other individuals in America who did see the power and potency of the rhetoric in Everson and anticipated that it would have the impact that it would have, in fact, what we've seen today, which is a rather systematic attack on the place of religion in public life.
Another brick in the wall of separation between religion and American public life came in 1963. In Abington Township versus Shemp, the High Court declared voluntary Bible reading in public school to be unconstitutional. Its purpose was to seek neutrality in public education regarding religion. But neutrality was defined through the preconceived terms of Everson's wall.
The First Amendment's purpose was not to strike merely at the official establishment of a single sect. It was to create a complete and permanent separation of the spheres of religious activity and civil authority. Majority opinion, the Supreme Court, Abington Township versus Shemp.
In a dissenting opinion, Justice Potter Stewart unveiled the real purpose behind this language of complete and permanent separation used in Abington.
A refusal to permit religious exercises thus is seen not as the realization of state neutrality, but rather as the establishment of a religion of secularism.
You know, one of the problems with the new separation of church and state holdings has been their grounding in a neutrality that is really a false neutrality. That by excluding religion, you're not being neutral, you're being hostile toward religion. Or adopting a view of religion that it has no place in public, but that it ought to be confined to the limits of one's own home, much like pornography.
What was the framers' view of secular government neutrality? Did they really want to segregate religion from their governing?
While just government protects all in their religious rights, true religion affords to government its surest support. George Washington.
At the time of adoption of the Constitution and of the First Amendment, the general, if not the universal sentiment in America was that Christianity ought to receive encouragement from the state. An attempt to level all religions and to make it a matter of state policy to hold all in utter indifference would have created universal disapprobation, if not universal indignation. Joseph Story, Supreme Court Justice.
By 1970, the Supreme Court had fully reversed its interpretation of the First Amendment from the original intent of the founders into a new paradigm of mandated secularization of the public square. In the next 20 years, new cases would produce a series of tests that would help the High Court legislate which laws were and were not an establishment of religion within this secular interpretation of the wall of separation. But in 1985, a diversity of opinion within the court began to stand out.